Gigi, sir, you have the floor. You are muted.
Good morning.
Good afternoon, Gigi.
Good afternoon. Pardon me. Good afternoon, colleagues. Good afternoon, Barrister. We really want to appreciate you for the work that has been done that has brought us to this point, the point where we needed to engage with our members and give more clarity within the context of what has happened in the last 1 week. I want to say that this is one of the many engagements we are going to have because with the way things are going, our legal advocacy will definitely be stepped up because the arbitrariness within the context of regulation and legislation it seems to be increasing. And the OPS have to be poised, have to position itself to engage constructively within the context of dialogue, and when necessary, to protect its interests, to protect its sustainability, and ensure its competitiveness. Legal advocacy might be a very big issue for us in 2025 and beyond. As far as they will continue their arbitrariness, then the need to protect our interests and protect our members will also continue to be top of our priority list. So it's going to be an interesting session. First, I also congratulate all of us because it's a win for organized businesses, as it were. And we hope that by the time we finish today, we'll have had the necessary clarity of the extent, the scope, the latitude, and every other thing, as lawyers we call it, of this judgment, and other ones that we might also institute. As we are smarting from the gain of this win, we also read of, we saw the new release by custom about the 4% charge again, which is another sore point for us and which we're already taking up. But we can't do this without the support of all members. Those that shared information with us, we want to appreciate you. Those that gave us some background information, we also want to appreciate your promptness in reaching out to us concerning these issues. And that is how we can really work and support your businesses. Once there is any information that seems confusing, that threatens our existence, we will advise that we promptly share with the Secretariat so that we can take up appropriate action to mitigate or to challenge those issues. So thank you once again for joining us, and we look forward to a very engaging and enlightening session from our lawyer. Thank you.
Thank you, Digi. For those people that joined the call at the beginning, I did say that the matter started in 2022. And interestingly, the then chairman of COLAX is still on this call. I'd like to yield the floor for him to say one or two things. Why did COLAX then advise the GC on this matter? Mr. Bodayeku, please. You have the floor.
Good afternoon, distinguished colleagues. It is my pleasure to be with you today. We are happy to deliberate on this judgment. When excise duty was introduced in 2022, you will recall that we had several engagements with our stakeholders, members of NECA, and then the external law firm that we work with in order to seek clarification from the court We are happy that eventually we agreed to ask the court for interpretation. It is good that this judgment is coming not too long from when it started, so it's not like the other cases that drag on for years. So it's an opportunity for us to just review the judgment and then align on the next steps so that we can advise our internal stakeholders on what to do going forward, and also further engagement that will be necessary with the relevant authorities. So I'm happy to be here, and I'm very sure that you are happy to be on this platform so that we can exchange views and then we can jointly agree on the way forward. So I thank NECA and the Secretariat for their support. We'll continue to support NECA, and NECA will continue to support us. We are NECA, so let's just work together collaboratively in order to achieve the desired purpose. Thank you.
Thank you, sir. Would like to take a brief profile of the speaker of today. Okay, please. The profile, please, okay. NECA had engaged the firm of G. Elias to handle this matter for us from start to finish. And G. Elias actually gave us one of its partners in the person of Mr. Stephen Chima Arubike. Now, he holds a Bachelor of Laws degree from University of Nigeria and also a Bachelor at Law from the Nigerian Law School. Interestingly, he graduated with a first-class honors from the Nigerian Law School and was one of those that got the prizes at the law school. His practice covers areas of tax, corporate law, restructuring, and dispute resolution. He's been involved in a whole lot of matters from start to finish. Mr. Arubeke has represented clients in semi-tax litigation before several tax tribunals and superior courts in Nigeria. He's a fellow of the Chartered Institute of Taxation of Nigeria, a member of the Nigerian Bar Association, the Chartered Institute of Arbitrators, Nigerian branch, Lagos Court of Arbitration, and London Court of International Arbitration. He actually handled the matter, and we thought it wise that he will share with us from start to finish what happened in the court, as well as give some insight into the judgment, which was delivered on the 30th of January 2024. We had invited him, and I know he's on this call, so I'd like to yield the floor to Mr. Stephen Arubeke. Mr. Stephen, you have the floor, sir. Kindly unmute, sir.
Hello, Thompson. Yeah,
Yeah, I
Thank you
can
very
hear you
much.
now. Go ahead.
Thank you. I have to change my system to be able to also show my video.
Well, the floor is yours.
Thank you very much, members of NECAS and the legal practitioners here present. So we're going to look into the judgment of the Federal High Court delivered on 30th of January 2025 in relation to the excise duties. As Thompson rightly noted, the case started about 3 years ago, precisely on 2022, on several issues pertaining to excise duties. So we're going to look, I will take you through the case. I will also shed light to the broad subject matter, the specific subject matters, and the interpretation of the judgment and how you can also approach the implementation. So you all recall that the Finance Act 2021 introduced excise duties for beverages by amending Section 21 of the Custom and Excise Duties Consolidation Act. However, we noticed that there is no specific provision under the law before then imposing excise duty on non-alcoholic, carbonated, and sweetened beverages. We also noted from the provision that there are 3 substances specified in the provision for the charge of excise duty. So shortly after, and it wasn't very clear on how the excise duties will be charged, given that beverages may contain 1 or 2 of those substances. Shortly after that, in 2022, to be specific, the Minister of Finance now came up with a circular to interpret the excise duty provision in Finance Act 2021. And looking at the circular, the minister in effect tried to expand the scope of the duties from the way we have read it, and also mention some other items, mention some items that will be charged, on which excise will be charged. Now, after that provision, we also got information from your team that the customs are also mandating members to incur expenses for their officers. So we're briefed to handle this matter. So from the broad subject matter, you can see that the subject matter of the suit borders on 2 things. First, on the interpretation of the excise duty provision in Finance Act 2021, and also on the entity to bear the costs and expenses of the Nigerian customs officer who are discharging their statutory duties in the plant and the premises of your members. So we now look into this subject matter in specific. Now, on the excise duty, we noted that there's no charging provisions in the law on the excise duty compared to other duties provided. We also seek interpretation on how beverages will be charged, because there are 3 substances mentioned in Section 17 of finance, in Section 17 of the Finance Act. That's non-alcoholic, carbonated, and sweetened beverages. So the issue that arose among the issues that we identify is that it's not very clear whether the excise duty will be charged when all these 3 substances are present in a beverage, or whether it will be charged only when one of them is present. For instance, you may have non-alcoholic beverages that have no, that is not sweetened or that is not carbonated, and you could have carbonated beverages that is not sweetened too, as a single item. And you can have sweetened beverages that is neither non-alcoholic or carbonated. So the minister tried to give a disjunctive interpretation to this provision, to the effect that once you have one of the substance in the given beverages, excise duty will be charged. So that's one of the specific items, the excise duty. So we now challenge the ministerial power to enlarge the scope of the excise duty in the law. Now, on the other, the second subject of the action borders on the liability on the expense of the officers of the Nigerian Custom Service who are undertaking statutory duties in the premises of the members. Now the main cross on that particular part, we seek two reliefs on the interpretation of the accommodation provision, whether the accommodation will be a lease to the Nigerian custom officer, because the provision in the law for the custom for the license holder to provide accommodation for the officers. So we seek a provision, we seek an interpretation of that provision, whether that should be a lease from the license holders to the Nigerian custom. And on the other leg of that course of action, we also notice that custom officers are demanding transportation, feeding, and monthly allowances from the excise, from the license holders. So we seek a declaration to the effect that such demand is illegal. Now, in the judgment, the court largely agreed with us on almost all the points. In the first place, the court held that the terms non-alcoholic, carbonated, and sweetened beverages in the Finance Act 2021 section 17 should be interpreted conjunctively and not disjunctively. Now, the import of this is that all the trace substances or elements must be present in a given beverage for excise duty to be charged. That is, such beverage must be non-alcoholic, must be carbonated, and must also be sweetened. In other words, if you have only one or two of these substances in the given beverages, excise duty will not be charged. So the court agreed with us on that point. On the second point, or a related point, the court have to construe the provisions of CETA on whether the minister has the power to enlarge the scope of items or products that will be liable to excise duty. The court held in effect that the minister cannot expand the scope, although the minister has the power to make a regulation. The regulation is limited to implementing the excise duties provision. In fact, we challenge, we also raise issues on whether at all any executive member can actually do that, because under the law, we found out that the president can, upon an order pursuant to the advice of a tariff review board, change or alter the item that will be liable to excise duty. The court did not specifically rule on the point, and it's understandable because the president have not actually done anything. But our argument still remains that even though the president is giving such power, the provision is actually unconstitutional, given that it is the National Assembly that has the power to impose excise duty. It is not the president, and that power cannot be delegated. But the court did not specifically rule on that. The court only ruled that the minister has no power to change, to alter, to increase, or limit the extent of product or item that will be liable to excise duty. So that is on the first subject of the action. On the second subject of the action that have to do with Nigerian Custom Service Officers' expense and cost. The court looked at the provisions of the law and ruled that, yes, there's a provision for license holder to provide accommodation to the officers of the Nigerian Customs Service who are undertaking their statutory duties in the premises of a license holder. However, that provision of accommodation is not a lease to the extent that the custom have to refund a license holder the expense incurred in providing accommodation to members. So the court did not agree with us because our condition that is a lease because of the way the provision was drafted, a lease to the extent that the custom have to refund or pay for that lease for the in respect of the accommodation that have been provided to each officer by a license holder. On the transportation, feeding, and monthly allowances, the court agreed with us that the provision of the law did not require a license holder to provide transportation costs, feeding expense, or incur or pay monthly allowances to officers of the Nigerian Custom Service. Although we also seek for a refund of the money that the license holders have been paying to custom officers in respect of transportation, feeding, and monthly allowances. The court did not grant that because, of course, we don't have evidence to show the actual costs that have been incurred on behalf of the members. We also sought a declaration for a refund of the excise duties paid by members illegally on the items that are not ordinarily excisable under the law. The court also declined to grant that relief because, of course, because we could not, the members could not provide the exact amount that they've been paying for items that are not liable to excise. And it's understandable because it's been an ongoing process from the time the implementation of the law started. Members have been making payment in an ongoing basis. So it will be difficult for us to quantify the amount that the members have already paid on items that are not liable to excise duty. So in effect, the court agreed with us on the two subjects of the suit, on the excise duty point, as I've mentioned, and on who is responsible for the cost, the officers. For accommodation, the members have to bear that. And we also noticed that while the suit is ongoing, the government also quickly amended the custom and excise duties, the custom act, to actually remove the provision that mandates that says that the provision of accommodation should be a lease. So in effect, that even if we are successful on that aspect because there's an overriding statutory provision that will not hold. But on the issue relating to transportation, feeding, and monthly allowances, the court was emphatic that there is no law that mandate an excise duty holder to bear the cost of the officers for their transport, feeding, and the monthly allowances. Now, we have received some requests from members on how to implement the judgment, given that the payment has already been made. A payment is due for January and so on and so forth. Now, there's no, we looked at the law, there's no provision under the law for under the Custom and Excise Duties Act or the Act for refund. However, it is always the law that once an illegal tax has been collected, that the party that bear the cost is ordinarily entitled to a refund from or a form of credit from the tax authority. Because we noticed that some members have products that are ordinarily not liable to excise duties because one or two of the substances mentioned in the Finance Act one or two of them is not present in the in that product. So how do you approach that? First, you have to request to the custom for a refund, and or if the custom cannot refund the amount, you can also the member can also ask for a tax credit in place of a refund. Now, in the event that the custom refuse to either grant a refund or a tax credit, any member that is willing can approach the court to enforce that provision, because there is a declaration that the collection is illegal. So it flows from that declaration that you can actually ask for a refund of any amount paid in relation to Excise. Of course, you have to bring in documentation to authenticate that such payment has been made, and that you are the member in question is entitled to a refund from the custom. So in summary, the law as it is today is that excise duty is only payable when all the three components mentioned in Finance Act 2021, Section 17, that is to say, the product or beverages, the beverage or beverages are non-alcoholic, carbonated, and sweetened. If one of them is missing, excise duty is not payable, because the court in emphasis say that the construction of the term should be conjunctive, meaning that all the items or elements must be present. Secondly, license holders are not responsible for the transport, cost of living, feeding, or monthly upkeep of the officers of the Nigerian Customs Services who are engaged in their statutory duty in the premises of the members. Third, license holders are only responsible for the provision of accommodation and office space for the custom officers who are undertaking their statutory duties in the premises of the members. So I think I've been able to give a brief explanation and implication of the judgment, and I welcome comments or questions from members on regarding the subject of the judgment. Thank you very much. Yeah, I can see Okay is raising his hand.
All right. I thank you so much. Before we go into that, the DG NECA.
Thank you very much. Thank you, sir, for that that clarification. I just want to, without breaking the flow, want to acknowledge the presence of NECA's first vice president, Mrs. Imka Deboye, the MDC for Cadbury. I think I saw her on the call. Good morning, ma. And also John Thompson to also appreciate the presence of Mr. Bode Ayeku, who played a very significant and very fundamental role in the institution of this of this case. I also have on the call Mr. Wale Jones, the Secretary for Association of Food, Beverages and Tobacco Employers, and also Mr. Rabafagun, the one of our key stakeholders, MD of Beggar Pains, and others that will acknowledge even as the session continues. We are not taking your presence for granted, and your presence also affirms the importance of this conversation, not only to NECA, but to all our members as it were. Thank you once again. Thompson, I hand over back to you.
Thank you. Yes, we're going into the question and answer session, the entire session. Let me, the DG has opened the floor. Let me join him with his permission to acknowledge other council members of NECA. Chairman Finance Committee, Mr. Muwa Adebayo, Mr. Femi Mokiko, you are recognized. Other council members recognize you. We'll go straight to the chat room. I'm aware there are questions there. We'll go straight to the chat room. Now, there is question from Nkem here. It says, it is very easy to quantify what has been paid. Sir, you omitted to highlight the court's declaration on whether custom is the appropriate collecting authority. Mr. Steve.
Well, I'm not sure the judgment did not, the case did not bother on whether custom is the appropriate authority for the collection. That is not really what we're asked to do. I mean, we didn't go into that. You can see that here. No, we're not questioning whether the custom is the appropriate authority. We are questioning basically the interpretation of the provision of the Finance Act. How will that provision be interpreted or construed? Specifically given the fact that members has products that have only the products that has only one or two of the elements, and we also look into the cost that custom, the illegal cost that custom has been mandating members to pay. So we are not questioning the authority of custom to do anything particularly. That's not part of our belief.
Right. Dr. Peter Idore asks a question. Say, by accommodation, do you mean residence and office space?
Yes. What the law says is accommodation, and also office space is a separate aspect of that provision. We didn't bring office space into the office space is not a subject of controversy. What we're talking about is residential accommodation for the officers of the Nigerian Customs Service who are undertaking their statutory duties in the premises of a license holders. So the interpretation is on the accommodation that is provided to be a lease on reasonable terms. A lease on reasonable terms. So our interpretation of lease on reasonable terms is that it should be a lease. But the court disagreed with us, by the way. The court disagreed with us because we looked at the provision and we say that the emphasis is a lease on a reasonable term. And if you say a reasonable term, what it means that the person that you are giving the accommodation should pay for it. Whatever the term should not be unreasonable. But the court disagreed with us. Because there are other inconsistent provisions in the act. So the court have to consider that provision holistically, because what the court is saying is, what the court said in essence is that because if you fail to provide that accommodation, there's a sanction to it. And they keep on saying there's also another phrase that said at its own expense. So the court look at all these provisions. Yes, it says a lease on reasonable terms, but also have to take into cognizance that there are other parts of the law that says at its own expense. So the court took a safer decision and construed it in favor of the government that the accommodation will not be paid for.
Mr. Steve, on a layman's perspective, I know we have a couple of lawyers on this call, and we have some non-lawyers. On a layman perspective, and someone were to ask you, if Thompson Food and Beverage Nigeria Limited, is Thompson Food and Nigeria Limited expected to provide accommodation to customs based on this judgment? Accommodation in terms of residence. Differentiate that from accommodation in terms of office. So there'll be two, residence and office. So should Thompson Food and Beverage provide accommodation for residence, and should Thompson Food provide accommodation for office to customs based on this judgment?
Yeah, they say the judgment by the reason of this judgment, I think the license holder is to provide accommodation as residential accommodation and also an office space, because office space is specifically mentioned. The law specifically mentioned office space and also accommodation. So you cannot read accommodation to mean office space. If the law have just specified stated accommodation, is a different thing altogether. But for the fact that there's accommodation, there's office space. So you cannot say the accommodation will also cover office space, given that the office space is also physically mentioned. You mention office space, mention other things that will even be in the office, lavatories, and so on and so forth, desks, and so it's actually specific. So we can now read accommodation to mean office space. Accommodation is a separate item in the list on what a license holder must provide to the custom officers. And office space is also mentioned specifically. So that is the problem.
Well, it is not a dialogue. Mr. Bodayoku, you have your hand up, sir.
But of course, we can still look. We can look at it that whether we can still consider whether we need to appeal, or I mean, if you review it and think is appropriate, or if government and I hope they will not first fire the shot, we can also take up some of the points that the court decided against the members.
Okay, Mr. Steve, thank you for your comments so far. I just need specific response on an issue. Do you advise member companies to stop further remittance of excise duty going forward, even if there is no clarity as to the backlog, what we have paid so far, even if we are finding a fresh action to recover what we have paid? Going forward, do you advise that from February 2025, member companies can stop remittance? Or do we need to do some other things before we stop remittance?
As the law stands today, you have the right to stop payment of excise duty if the three substances mentioned are not present.
Okay.
If you have only non-alcoholic that is not sweetened, non-alcoholic that is not carbonated, by the terms of this judgment, it is very clear you have to stop payment. But if you have three of the items in the product, you have to pay. So it is not, you just have to be able to look at the product in question and see whether it satisfies the criteria under the judgment. The court say that unless the three substances or elements are present, excise, the product is not excisable unless the law will change tomorrow, and we don't hope for that.
Yeah, I'm actually talking in respect of those companies whose products do not satisfy the three preconditions.
Yes.
Okay. Do they need to do anything before effecting the stoppage of remittance? Do they need to write custom to say, based on this judgment, we are not doing X, Y, Z again, or it is just to get clarity?
I don't think you need to write custom for anything. You don't need to write custom. The court pronouncement is a court pronouncement.
Okay. And have you written on behalf of NECA to custom to draw the attention to the judgment?
We have not done that. The custom and the minister, the finance minister, are parties to the case. We sue custom and we sue the minister, and both parties were fully represented.
Okay, but is it out of place for you as the law firm that was engaged by NECA to actually write them again just for formality to say, based on this judgment, you have advised your clients, the members of your client, to stop that satisfy the requirements, the three preconditions that do not satisfy the requirements to stop remittance? It's just as a precautionary step.
If you want, although it's not a part of our brief, but if you want us to do that, I will discuss with Thompson. We'll do that for you. It's not a problem.
Writing letter to
Thompson is smiling. We'll do that.
Steve, writing letter to communicate judgment to the parties.
We'll do that. We'll do that for you.
Okay, thank you. Okay.
We'll do that for you.
Okay.
But also remember, once you start writing them, they will also start thinking of the prospect of appealing the judgment.
I know it's just to prepare the grounds, just to say.
No, not a problem. We'll do that for you. Please note that we are going to write a letter to the custom and the minister of Finance, drawing their attention to the judgment. We also include a copy of the judgment for their records. But like I said, they were in court.
And also, please add the other leg to say you have advised the members of your client that do not fall within, that do not have the 3 preconditions to stop remittance, so that you put them on notice.
Not a problem. We'll know how to write out such a letter. I mean, we'll draw their attention to what we do is to draw their attention and also informing those people that are enforcing the collection to stop doing so, unless they are doing so on the terms of the judgment.
Okay, thank you.
So we can assure you that we'll follow up with Steve because you will have to give us an acknowledgement copy. Okay, your hand has been off for a while. Please, before we get back to the chat room, you have the floor. Okay.
Okay, thank you so much. Can everyone hear me? Can you
Yeah,
hear
I
me?
can hear you. Please go ahead.
Okay, thank you. Mr. Stephen, thank you so much for taking our time to shed some light on the implication of this groundbreaking judgment for the industry. We appreciate your efforts. We do not take it for granted. So just a question for me, which I had actually put in when I was registering for this particular session. Now, if you go to the end of that judgment, where the court made orders, order 5 that the court entered says specifically, an order is made directing the first defendant forthwith to stop the collection of excise duty on non-alcoholic, carbonated, and sweetened beverages from members of the first plaintiff, including the second and third plaintiffs, pending when the provisions of Section 13 of the Customs Excise Tariff etc. Consolidation Act are complied with. Now, some days ago, there was a publication in the front page of this day newspaper saying court directs, or rather court stops customs from collection of excise duty. Now, that order the court made towards the end of that judgment is very clear. See, it does not even talk of whether those 3 elements that you mentioned, whether all of them are there or not. It's an absolute order. So, and I believe that it was on that basis that NECA went, or rather, sorry, it was on that basis that that publication was made on this day newspaper. So now, but from what you've said so far, it appears that we can only stop paying only when any of those 3 elements is lacking. In other words, it's not present. But from the order that the court made in specific and clear terms, it says stop paying. It does not situate it to any, it's not a conditional order. In other words, it didn't say it's only when these conditions are met or are not met before you stop paying. It says pending when the minister complies with Section 13 of the finance of the Customs and Excise Act. So that throws some kind of confusion as to whether yes, we should even pay or not. The issue of stopping to pay regarding any product that does not meet the 3 conditions, that one is clear. At least for me, it's clear because, for example, juice is not carbonated. So, but this particular order that the court made, which is very clear, and on the basis of which I believe that publication on this day newspaper was made, that front page was made. How do you reconcile this apparent seeming confusion?
Yeah. We also noticed that confusion, and the reason why there is confusion is that specific order is contradictory in a way, because if you have read the entire judgment, you discover that issue was specifically decided against us. That is the first issue that the court decided. So if you look at specifically, just take a look at page 33, 34, yes, 33, 34, and the first paragraph of page 35. The court resolved that issue against the plaintiff. Is rather, I mean, is now contradictory that after resolving the issue against NECA, we still see that particular declaration at the end of the judgment. So if that judgment is to be either ratified or to be, interpreted, so to say, maybe let me just use that term, though some say you don't really interpret judgment. It's probably that was actually perhaps was made in error, given the analysis that the court gave. And that's the first analysis in the judgment. The court first decided the issue because we actually raised issue on whether another law is required before excise duty will be charged on non-alcoholic, carbonated, and sweetened beverages. The court said that is not a true reading of the provision. That provision charge excise duty and at the same time specified the rate. He said, I don't know if you want me to, I can read it clearly maybe for the. So I do not agree with the plaintiff counsel argument that there is no indication on the face of the amendment specifically imposing excise duty on the manufacturers of non-alcoholic, carbonated, and sweetened beverages and empowering the first defendant to charge such duty. It is not being contested by the plaintiff that the National Assembly lack the power, lack the competence pursuant to Section 4 of the 1999 Constitution to have amended Section 21 of CETA by the addition of subsection 3 to the same. I therefore resolve this issue against the plaintiff. So it's rather unfortunate that they still bring, but we still see that particular relief was specified as decided in favor of NECA. So if you read that judgment holistically, I mean, you agree that it's a bit inconsistent, but the body of the judgment, which is more important than the order specified at the end, is not in dispute that the court resolved that particular issue against NECA. Thomas, I can't hear you.
Okay, I'm saying I want to go to the chat room. A couple of questions there. Mr. Adewale Jones says, do you envisage challenges in the process of implementing the judgment?
Of course, Nigeria is what it is. They could be, I mean, custom may kick from the administrative standpoint and also from a legal standpoint, they may also appeal. But you already have a judgment. For them to not to enforce that judgment, they will require a specific order from the court that suspend the enforcement of that judgment. So to the extent that we don't have such order prohibiting or restricting the enforcement of the judgment can be enforced. But of course, from the administrative standpoint, custom may not want to enforce it, but we also have a legal machineries to ensure that the custom comply with the order. As at when that arises, you can let us know. We'll know what to do.
Talking of appeal, there is a question on appeal down there. And that is to say, if they actually decide to go on appeal, right, which is within their rights to do, and a motion is filed, what will be the implication for businesses?
Well, if a motion is filed, the way the Court of Appeal rule is written, once the motion is filed, it will amount to a suspension of the terms until the court decide otherwise. Of course, if they file the motion for stay, we'll challenge it.
No, I didn't quite get that. Does it operate automatically as a stay?
Yeah, yes, it does. But though it's a bit problematic here because here there's really no the court only said this is the way the law is interpreted. So you have to respect that appeal as long as it's filed within time and comply with the law until a decision is made. If there's an appeal and a stay application, it will operate as a stay. It ordinarily operates as a stay. But we'll look at it. We'll look at it in terms of the content of the judgment. But ordinarily, the Court of Appeal rules is now clear on that that once there is an appeal and a stay properly filed, you cannot do anything until that stay application is entertained and decided upon.
Okay. There's a question from Zainab here, and I'm trying to bring it up. And it's talking about the is it based on my experience? I'm reading the way she wrote it. Based on my experience, the custom will only recognize orders of instruction from Ministry of Finance and not law or court judgments. How do we stop custom from resuming at the premise of companies whose products do not meet all three conditions? Mr. Steve, you appeared. Did you get that?
Yeah. Please, can you repeat that question again?
Based on my experience, reading as written, the customs only recognize orders or instructions from the Ministry of Finance and not laws or court judgments. How do we stop the customs from resuming at the premises of companies whose products do not meet all three conditions?
If that happens, please let us know. There are ways to enforce, there are ways we can activate the enforcement procedure to ensure that custom complies. And we are also advocacy body. So you can also make noise in the press about it. But as a matter of law, we are going to take steps to enforce it, and any officer specifically in violation of the terms of the judgment, you can also let us know about that, so that the enforcement proceeding will be specifically targeted at that custom officer who is violating the terms of the judgment.
No, based on the principle of ex abundantius cautious, don't you think we should go that route? Because by the time they go there to companies, they have disrupted operations.
No, the reasoning, of course, for you to, if you want to cite a party for contempt, of course, somebody must have done something to that effect. But you don't need to wait, until they disrupt your operation. Like you have rightly suggested, we'll write custom. We can copy you can let us know the zonal branches or offices that we need to copy. Because before instruction will come from the headquarters to the zonal distance, it may take quite a while. And so you can also let us know, so we can copy the respective zonal offices that are in charge of the enforcement of the excise duty collection, so that they will also be aware.
I'm picking this on the middle of the conversation. It says, considering the contradictory parts of the decisions you explained during the call, right? Do you consider to apply to the court for clarification or ask to amend the final declaration part of the decision?
I don't really think you need that. The contradiction is in your favor, in a way. If the contradiction is actually against you, now maybe let me explain. Maybe the court made a favorable declaration or decision in the body, and now put in an unfavorable order. We can apply. But in this case, the decision was entered against NECA only on that issue. Then a favorable declaration was made in favor of NECA. If once we approach the court will quickly rectify that. But I don't think it is it be not beneficial to you. Thompson, what do you think? We can do that, but it's not beneficial.
Hello, for me, we should not use our torchlight in the daytime. The judgment as it is beneficial. Let's not go and ask the court to sit on as an appellate court on its own judgment. Let us just work on what we have. Whichever interpretation you have is still beneficial. Let the other parties worry about what to do to seek clarification. That will be my personal view on that.
I agree. Totally agree.
I agree, because the court becomes functus. Now, before we continue on the chat, there's a hand up. Oh, I thought I saw Ike Oluwa is dropped. Okay. Mr. Additional Salau, you have the floor, sir. But kindly give him the right to speak. Mr. Salau Additional. So you may wish to unmute.
Okay, thank you. Can you hear me now?
Yes, we can.
Okay, thank you very much, Thompson and Steve. Happy New Year to you both and to everyone I've not had occasion to speak to this year. Yes, my hand has been up for a while, and we are not really affected directly by this, but we're a member of NECA, so we're interested in this regulatory litigation. I just have few. First is a question and then a comment. My question relates to the section of the Court of Appeal that Steve cited, that once a matter is on appeal, the parties should just, abide. That is not particularly clear to me, because what are the parties in this case abiding with? Noting that the claimant is the industry, okay? Now, so what is that rule talking about? Is it saying that the custom should abide once an appeal is filed, in which case the custom has to do nothing than to try to attempt, because again, we have to note that this kind of litigation speaks to the purse. It's about the money. And also think in terms of strategy that the government is not likely. It's not just a declaration that the custom officer has no right to slap somebody. This is about the revenue that accrues to the federation. So they'll be thinking big, or even bigger than we think is just a litigation strategy. That's the first question. Second one, which is a comment, is a rider to what Mr. Ayiku has said, to which I agree completely, that it is not time to start torchlighting where there's no need for it. Albeit, we can plan down a strategy, and that speaks to Steve and what your team will be doing. In the event that they file a motion for stay of either execution or proceedings to the judgment that you have, usually, what you will be entitled to at that time is that, okay, parties are not allowed to do anything. So I would imagine that if they file a motion for stay, their intention is to say to you that the judgment that you think you have today should not, be complied with by you. That would be effect of such a stay order, if I be right, yeah? So yeah. Therefore, I think what we can begin to think about is once an application for stay is filed, noting that the regulators will just go to the streets and say, yes, you think we have a motion for stay and we have an appeal. And so we want to go ahead and at least attack some organizations that they have not really, given any notice before. It will be difficult then to start moving. So my proposal would be, will it be wise to file a motion for injunction or a cross injunction as soon as they file a motion for stay, restraining them from touching any affected body until the appeal is ultimately resolved? That way, you can hold any of the custom papers or notices that come to you to say, look, you have a court order saying both parties should not do anything. That will be clearer. I agree. Do we file that motion now? No, but you can do that as soon as you see cases of appeal and motion for stay. So those are my suggestions and the question. Thank you.
Yeah. I think that suggestion is good. I mean, that's what we can do. Because like I mentioned when the issue on what happens when appeal and a stay is filed, that when you look at the terms of the judgment, it's not very, very, I mean, it has a different flavor in a way, because you are not doing anything. It's actually a custom that is firing shots illegally as it is currently. So if they take that step, we also file an injunction to stop them, because when we actually sought for injunction, but the court did not grant. The court did not specifically, made a pronouncement on that. So if they file for a stay, we also we file an injunction to stop them from taking any steps.
Yes, Mr. Additional Salawu.
Yes, sir. Thank you, sir.
Mr. Salau, your hand is up.
Sorry.
You have the floor, sir.
No, sorry. I think it's just a cross event.
Okay. All right. Thank you, sir. Now, I go back to the chat room there. There are a couple of questions that are there, and I would just want to read them out. Right. There's one from Mr. Amba here. Says, please confirm that the appeal period is within 30 days. And with this explanation, and given that the appeal period is still open, I suppose members should accrue to the excise in January and February until the appeal period is over before we can decide not to remit, right? If custom do not appeal the judgment. And if they appeal, I will have the rights, we'll have the right to remit the accrued excise rather.
You don't need to be remitting until the appeal period. Appeal period is actually 90 days. So it's not 30 days. And you don't need to wait until the appeal period is over. You have to stop collection for you, because the implication of the judgment is that this law, the custom demands have been illegal ab initio from the time they started enforcing the provision against products that are not liable to excise duty under by the terms of the judgment. So, of course, it's on that basis that you are asking for a refund. But what it means that the collection made so far ought not to be made. So there's no need for you to wait until the appeal period is over before you stop paying this thing to custom. Unless they have file a stay, maybe we can say, okay, because there's sometimes the court will say respect the terms of it will become an open issue. We can argue that before the court, but as it is now, payment should stop, and the custom or the minister are supposed to refund whatever you have paid under a product that is not liable to excise duty.
Reading from Mr. Mokiko's contribution, it says, if the Act requires the provision of residential accommodation for such officers, it will be interesting to know if custom itself provides accommodation for officers of the same cadre in the same location as member companies. Whatever interpretation to give to the accommodation must be drawn from their practice. It's making a contribution to it. And this question says, can we on the basis of the judgment stop paying excise duties on non-alcoholic carbonated and sweetened beverages? Did the court hold that custom lacks the power to collect excise duties on non-alcoholic beverage? Steve?
Yeah, I know we answer. Yeah, like I stated, I think we have addressed the contradictory aspect of that judgment. But when you look at it critically, what the court is saying is that excise duty will only be payable when all the three components or substances are present. So,
okay,
you still have the right to pay excise duties on product that has all the three substances or elements.
The person continued by saying, will the judgment be applied retroactively?
Yeah,
I think
I mentioned that before. What it means, what the judgment means that from the very day that the custom started enforcing the collection on, let's say, juice, is illegal. It is an act. It's not from the day the court entered the judgment, and that's why we are talking about refund or tax credit. So it's like saying that you don't have right to do this. The prohibition did not start from the day the judgment was entered. It starts from the day the party that have been collecting excise duty illegally commenced that collection from the very first day. So that's why it's not, I won't say retroactive or this thing. It's just a normal, that is how laws are interpreted. If you pass a law today and that law is declared tomorrow, the illegality still start from the day the law was passed, or from the implementation of that law commenced, not necessarily the day the judgment was delivered, because the judgment relates to the day the officers started enforcing the illegal collection.
In this case, it will now take us back to 2022 circular.
Exactly, from the 2022 circular, because in fact, just to mention, the court declared the circular invalid and void. So whatever the customs officers have done pursuant to that circular is illegal, because the court declared the circular invalid and void as it relates to the expansion of the sizable product under the law.
Can we ask the custom officials in our offices to now leave the premises and obviously stop paying for their feeding, accommodation, and transportation?
Well, I don't really know the nature of your products. I don't know. I mean,
carbonated, non-alcoholic.
If your product falls within the scope, they have to be there, but you don't need to give them food, or give them pay for their transportation, or give them monthly allowances. That have to stop, unless you want unless you want to do it as a gracious act. Of course, some people give me water, give me some give us like Thompson have been promising me lunch. You don't need to give me lunch on that. Oh, I'm promising Thompson lunch. It's a gracious act. I mean, you are not under compulsion to do that. I mean, if you are eating and you have your neighbor around and you want to eat, you can ask the person to eat, but you don't have the legal right to demand the transportation, the cost of living, or feeding allowances. You have no right to demand that, and as I understand, they even add that this money have to be paid into specific accounts, which even have the coloration of corrupt practices in a way. And in fact, that's basically why we have to include that prayer, so that some people will not be accused of doing something illegally. But for the accommodation, you provide them with the accommodation. You are not meant to go and pay money to anybody's accounts. As long as you have provided them with accommodation, you don't need to demand reimbursement. You are not meant to go and pay money into anybody's accounts.
I think that's all the question in the chat room, but there's a hand up. Okay, please, you have the floor.
I think he raised that hand previously, and we have addressed his concern.
Okay, please, you still have the floor. I think he still want to speak. I think he was talking about being muted.
Yes, you were muted. I was muted before. Okay.
Okay, apologies.
Yes. Mr. Rubike, please, there's still some kind of ambiguity that I would like you to maybe throw light on. You know, why we approach the court, the first relief, or rather the question we asked the court to answer, we said, one, that there is no law creating that particular excise duty. And then that's the first part of the issue. Then the second one was that there's no law empowering customs to be the collecting entity. In other words, empowering them to collect that listen. So, but the part of the question which I discovered that the court answered is the first leg of it, which is whether there's a law that imposes excise duty. The court basically answered that one against us. But then the second leg of our argument, which is that there is no law empowering customs itself to be the entity that collects that excise duty, that particular part, I didn't see anywhere in the judgment where the court answered that question. In fact, if you check the circular, you see that it was that circular that actually appointed customs as the collecting entity.
the entity that collects. But then that particular circular was set aside by the court. So I don't know whether you get the point I'm trying to make.
No, I'm not sure. It's I remember vividly, and we tinker with this relief extensively. I'm not sure the question on the appropriate authority for the collection was raised in the relief. No, it's not. What we're concerned about is whether there should be another law that charge for excise duty. We are arguing that Finance Act only set out the rate. I don't know if you have any. I mean, if you can refer to me the specific relief or declaration. I don't think is an issue. I don't think it's an issue because the appropriate agency to collect it will not even be an issue to the extent that it's going to the coffers of the federal government. So whether they want FRS or custom to do it, we will not even have local standing for to start questioning that on the appropriate authority. If you say it's not custom that will collect, then the minister can designate some other person to do it. Because the most important thing is that the custom and excise duty is under the jurisdiction of the federal government. Any of the agency that they designate to do that is not really a problem of the party paying the duty. I don't know. I think that's what I think about it too.
But are we talking about the same circular that have been declared null and void by the court?
Yeah, the court declared circular null and void to the extent that it tried to expand the scope of the excisable products.
Okay. I understand the argument.
If the minister decided to pass a circular and say that custom officers should stay in this particular area to collect it, it's an implementation action by the executive. It has really what we are concerned about the part of the circular trying to extend the scope of the duties, trying to interpret that use product that has just one of the three components will be liable, will be excisable under the law. That is the part that we are concerned about. And of course, on that basis, the circular will be declared null and void. But to other things that have nothing to do with expansion of the scope of the duty, the circular is still okay for the officers.
We have Madam Kim San up, please. Madam, you have the floor.
Okay, thank you very much. Thank you so much, Thompson, and thank you so much, Mr. Arubike. I have a question. You know, we keep trying to anticipate what will be the response from customs. But maybe another approach we can take is to actually go and engage with customs and say, this is the judgment. How should we proceed? Let's agree what the way forward will be. For me, I agree entirely with Mr. Arubike, the meaning of that judgment. If any of us takes the position of deciding not to pay any excise at all because the literal interpretation of the order suggests that, I think that would be very risky. I think the best way to understand the judgment is that you're paying excise on anything which is collectively non-alcoholic, sweetened, and carbonated. But having said that, in order to avoid an appeal or a motion for stay or an order for stay, maybe we could just engage with customs and say, what's the way forward? And if we did get to a point where customs is appealing and applying for various stays, then maybe our response should be to be paying our excise into the account of the courts. Let the excise not get into the coffers of customs at that stage, but we just leave it with the courts for two reasons. One, so that you stand a chance of getting the money back at some point in time. And two, also so that customs will still be deprived of that revenue and perhaps will want to discuss with us. That's just my contribution.
Thank you very much, madam, especially on the part regarding request to pay into the court accounts as at when the custom people filed a motion for stay. I mean, that because well, part of the challenges that we are facing now is how to get a refund of tax credits. So at least going forward, if we have this money paid into the court account, we will not be talking about how this money paid into court account. The issue on getting a refund or tax credit will not arise, because the court will just make once the judgment is decided finally, the court will make an order for that money to be transferred to the rightful party.
I just need to add my comments, my personal view for consideration of all stakeholders. Personally, we all know that custom has a target of revenue to get, and that means that they will do whatever is necessary to meet their target. Consequently, it is my view that we should not engage with them on the way forward. If you do that, they will say the way forward is continue to pay until a decision is taken. Let them bother about what they want to do concerning the way forward. Let us consider our way forward in terms of strategy. And that is why, personally, I would say let our lawyers write them, forwarding the judgment to them, even if they have, and to say they have advised their members to be guided accordingly on this. However, that letter should not be asking for a refund, because that will agitate them to appeal. It's just to say more of going forward. So you technically avoid the issue of refund because they will be agitated. That would be my strategy. When the letter gets to them, they will then decide what to do. If they are filing an appeal and a notice of stay, then we can, in our cross interlocutory application, also say, okay, pending the determination of this appeal, that any payment should be made to the cost account. I think in terms of strategy, that would be my personal view, subject to the comments of other stakeholders.
Yeah, our letter will not ask for refund. I mean, but Thompson, you talk to your members, because refund is specific to members. It is not to NECA as a whole. And in fact, that was the reason why the court could not have grant relief on this thing. So maybe we'll just hold on for refund, because you can always get your refund, so that we don't trigger adverse actions from customs, so that we can be thinking of going forward now on what happened. Later, members can, I mean, you are not, you can always ask for, you can always enforce the terms of judgment anytime.
I think there are no more questions in the chat rooms or comments, and there are no more hands raised. There was a question that actually stepped down, and I want to go back to it. And was there a question or a contribution? And that has to do with the 4% FOB, recently triggered by customs. The 4% FOB, recently triggered by customs. And I just wanted to put it this way. What are your thoughts, Mr. Rebecca?
I need to look at that specifically, but because as lawyers, we always be guided by the law. If it is introduced based on law, I mean, you have to pay. But if it is not based on the law, we protest. But I have not looked at I don't have the provision before me to actually give my interpretation on the terms of the 4%. Is it whether it's based on the law or not? I mean, if it's based on a valid law, you have to pay it. They have a right to increase. Even the matter we are talking about that was done illegally, if they decide to go and take the route of going to the National Assembly or the appropriate authority, there's definitely nothing we can do. Tax is a matter of law. It is not a matter of morality or ethics. If it is stated in the law and the authority that charged the tax has the right to do so under the law, there's really nothing you can do. Of course, you can always engage in advocacy, enlightenment, trying to, lobby the National Assembly or the executive to pause the implementation or to look at the hardship. But as a matter of law, you have to comply with the law. That's my thought on that. Thank you very much, Thompson.
Yeah, okay, has made some contributions. It says it's a function of that the Customs Service commenced yesterday the implementations of the provisions of the new Custom Act, and it's based on Section 18, Sub 1, Sub A of the Nigerian Custom Act 2023. It's an enabling law. Finally, there's a hand up. I'd like to take that as the last so that we can wrap up this section. Charles Mba, please, you have 2 minutes. Mr. Charles
Okay,
Mba,
yeah. Hello, good afternoon, everyone.
Good afternoon.
Just to confirm, I suppose the period open for an appeal is 30 days.
No, this is a final appeal. I think it's 90 days.
90 days.
Yes.
Oh, okay. So ordinarily, one would have been.
It's not interlocutory appeal. Even interlocutory appeal is 15 days. This is a final judgment.
And if for any reason custom files maybe after 60 days and the stay is established, will they not be demanding for the excise even from January, February as well, even if they filed 60 days after, I suppose?
No, I don't. Once that month has passed and you didn't pay, of course they will always if a stay is granted, that means you have to be paying going forward. But we have also discussed on how to approach the stay application file, just to ensure that there is a form of mutuality. We can also request that the money be paid into the court account. And if the court orders that the money be paid into the court account, even the January, February duty will also be remitted to the court account.
Okay. So I suppose the major engagement with the customs authority might become very much effective after the period of appeal, because then we then know that, oh, this is a conclusive position since they did not file, if they do not file within the 90 days, because any conversation right now can always be can trigger them to quickly go for the appeal, because sometimes they may even forget to do that. So
that have been my suggestion, Thompson. Because once you start writing custom, they will remember that there's a judgment against them. I don't know. But we can reason and review this position, and you decide and instruct us on what to do.
You are hereby instructed as discussed.
What is as discussed?
Yes, please go ahead and do the letter. Go ahead and do the letter. The reason is because when they see that the income from that source is no longer coming up, the question is, what happened? So please go ahead and do the letter.
Not a problem.
Thank you.
We'll share a copy with you shortly.
I appreciate that. Let me at this point appreciate everybody that has been on this call. We have been here looking at the participants. We have 94. By the time we got up to 100 and on and on and on like that. Let me just thank my council members that are still on this call. Let me thank my past president, Colax, Mr. Yoku, and other members of Colax that are on this call. Let me just thank members of NECA that are here. But eventually you are on this call and you are not yet a member of NECA, I will strongly encourage and advise that you pick up a membership application form so that you get to enjoy some of the benefits from NECA, one of which is this case, and this knowledge which you've also gained is also another one. Because NECA is there to protect the interests of all businesses through all legal and legitimate means. And if you're not in that fold, sorry, you have actually do miss a lot. We have a couple of other engagements. We have a couple of other advocacy activities. Strongly on our radar is that of the National Assembly. And so we'll be encouraging that if you have received any love letter from the National Assembly, I choose to use the word love letter in parentheses, between November, December, January, and this February, please do share with your NECA secretariat. We have a couple of things. I know we have taken custom to court, we've gotten judgment. We took Kano State government to court, we got judgment. So court is not like something we're afraid of, but it's something that we believe strongly in, we'll do so. but we always do that as one of the very, very last options. And on the NECA platform, we have a couple of programs lined up for the month of February. I'd like Okpe to help me share some of the flyers. So I just speak to them. We have our data privacy and cybersecurity program coming up, and is a paid program. For members of NECA, it's 100,000. Non-members is 110,000 and is a 2-day program. Please note that the subject of data privacy, data protection is something that we cannot run away from. It is come to stay, or it has come to stay, or it is stay. So it is advisable that you do that so that you don't run foul of the law, as ignorance of the law is deemed to be no excuse. Okay, the next flyer. Thank you so very much. We have a program here on human resources and people analytics. It's also a fee-paying program, 25th, 26th February 2025, 25 and 26 of this month. As I said earlier, it's a fee-paying program. And for the NECA member, it is discounted as usual, 150, while non-NECA members pay a bit higher. And the duration for this is 2 days. It's a 2-day program so that we get to know what to do. The world of work is changing and will continue to change. So we need to be on top of our game. And if you are not in this category, you can share it with your colleagues in your HR or personnel department. Then the next flyer, okay, thank you so very much. We look forward to having you all at our 3rd annual labor adjudication and advice and arbitration forum. This is very critical. It's team labor adjudication and appellate jurisdiction challenges and prospects. His Lordship, the President of the Court of Appeal, will be the keynote speaker. She's confirmed, and certainly she'll be there with some of Milords from the Court of Appeal. Milords, the President of the NIC, will also be in attendance. I'm talking about Honorable Justice Benjamin Kanyip, OFR, alongside with other Milords from the NIC. Why the distinguished special guest is the Director General of the ILO, the DG of the ILO. And interestingly, it will be the very first time that he'll be coming to Nigeria. And the program is scheduled for Abuja, 13th of February 2025, 13th February 2025, 8 a.m. And the venue is the National Institute for Legislative and Democratic Studies there in Abuja. We're coming to discuss a couple of things, but basically it has to do with labor adjudication and appellate jurisdiction. Sometimes you file cases and you find out why are employers not getting judgment? Why is it the union? Why is it this? Sometimes the employers are not doing what ought to be done. And so we're going to hear from those people that are presiding over these cases, from the NIC to the Court of Appeal, which has the final jurisdiction, or the final jurisdiction in terms of appeal from labor courts is the Court of Appeal, and the president will be leading that discussion with us. Thank you, Okpe. Next flyer. So please be a part of it and be there to engage us actively. I don't know if my DG is still on the call. I wanted to invite him for a closing remark. DG Neka, are you there?
It's not on the call.
It's not on the call. Dr. Tola, are you on the call? Nika, I just wanted to yield the floor to other directors, please.
Yes, I am. Hi, Thompson, and good afternoon, everyone.
Good afternoon to you, madam.
Okay, you would like me to close this, right?
Please do a word of appreciation and closing.
Thank you very much. And thank you very much to all our members and non-members. All of our programs that are in line. It's been a heated
It appears the network is not friendly from our end.
Conversations and what do you say?
Go on, ma'am.
Okay. So you've been a pillar of support and we really thank you. We appreciate all your efforts. To my colleagues of the in the secretariat, thank you all for ensuring that we had a smooth operation for this KSS, and we look forward to having members and non-members. Please, Thompson has encouraged everyone, if you've received, if there's a letter you've received, please do well to send it to us so that we can advise. We are more than able to support you because that's what we're here for. And our hands of support reach out to you as often as we can. To everyone who's asked a question, thank you for all the clarity. Thank you for the questions. You not only asked the questions, but you enlightened us as well, because as the questions were being answered, we also learned from it. So thank you, everyone, and enjoy the rest of your afternoon.
Good afternoon and enjoy the rest of the day. Thank you so much.
London. I'm feeling vibes on vibes. I'm a ticking dynamite. I blow your candle lights. You know I'm just that type. No, them no fit kill my vibe. Them no fit kill my vibe. Them no fit. There you shall find a piece of advice. If you hit your enemies, enemies shine. If you're not a friend of me, enter the light. Cause you can never kill my vibe. Got here with no sacrifices. Everything was taken, still had to make it. Vibe killer, me I no go take shit. Vibe killer, bloody somebody time. Protect my energy from your bad aura. Then my pastor say I be my healer, everything I desire. I go receive my rhythm, flow like a river. If you get yawa, come on, pass it down. I go just para, come off my jigger. I go just follow my dream. I'm feeling vibes on vibes. I'm a ticking dynamite. I blow your candle lights. You know I'm just that type. No, them no fit kill my vibe. Them no fit kill my vibe. You no fit kill, you no fit kill, you no fit kill my vibe. I see you watching my stories. I see you gauging my lifestyle. I see you watching my movements. This bad bitch bad every day. I know they look at your face. Bad man bad every day. Get on your knees and pray till you regain your faith. Bloody somebody time, protect my energy from your bad aura. Let my pastor say I be my healer, everything I desire. I go receive my rhythm, flow like a river. If you get yawa, come on, go and sit down. I go just para, come off my jigger. I go just follow my dream. I'm feeling vibes on vibes. I'm a ticking dynamite. I blow your candle lights. You know I'm just that type. No, them no fit kill my vibe. Them no fit kill my vibe. You no fit kill, you no fit kill, you no fit kill my vibe.
I know sometimes it be like say nobody send you. That's when I pray for you, my friend.
Party no vex for me. Say I never go you since, but I hope that you are well. I hope your market sell. Every day I dey pray for you. Make you Baba God bless you. I never forget you. I gon' forget you. See my shoulder.